In the matter of HYATT International Southwest Asia Limited versus Additional Director of Income Tax, Supreme Court dismissed the appeals and affirmed the findings of the High Court that appellant has a fixed place, permanent establishment in India within meaning of Article 5(1) of the DTAA and that income received under the SOSA is attributable to such permanent establishment and is therefore taxable in India. Court also noted reference made to larger bench of Delhi High Court in HYATT International Southwest Asia Limited versus Additional Director of Income Tax, where it was held that profit attribution to a permanent establishment in India is permissible even if overall foreign enterprise has incurred losses. The principal issue that arose for determination herein was whether the appellant HYATT International Southwest Asia Limited, tax resident of the UAE, has a permanent establishment in India under Article 5(1) of the Indo-UAE Double Taxation Avoidance Agreement and consequently whether its income derived under the Strategic Oversight Services Agreement is taxable in India. Article 7 of the DTAA governs the taxation of business profits. Article 7(1) provides that profit of enterprise shall be taxable only in the state of its residence unless enterprise carries on business in the other contracting state through a permanent establishment situated therein. In such a case, only so much of profits as is attributable to that PE may be taxed in the other state. It is evident that the appellant's role was not confined to mere policy formulation, said the court. On the contrary, the SOSA conferred upon the appellant is a continuing and enforceable right to implement its policies and ensure compliance in all operational aspects of the hotel. The degree of control and supervision exercised by appellant clearly transcends mere advisory capacity and aligns with criteria for a fixed place permanent establishment under Article 5(1) of the India-UAE DTA. The question of what constitutes a place of business under Article 5(1) of DTAA is no longer res integra. In Formula One case, the court unequivocally held that for a permanent establishment to exist, two essential conditions must be satisfied. The place must be at the disposal of the enterprise, and the business of the enterprise must be carried on through that place. Court further held that a permanent establishment must demonstrate three core attributes of stability, productivity, and a degree of independence. Among these, disposal test is pivotal, meaning thereby that the enterprise must have a right to use the premises in such a way that enables it to carry on its business activities. The argument that absence of a specific clause in the SOSA permitting conduct of business from hotel premises negates the existence of a permanent establishment is also without merit. As held in Formula One case, test is not whether a formal right of use is granted, but whether, in substance, premises were at the disposal of enterprise and were used for conducting its core business functions. In the present case, detailed review of the SOSA executed between the appellant and AHL demonstrates that appellant exercised pervasive and enforceable control over hotels' strategic, operational, and financial dimensions. Specifically, the agreement vested the appellant with powers to appoint and supervise general manager and other key personnel, implement human resources and procurement policies, control pricing, branding, marketing strategies, manage operational bank accounts, assign personnel to hotel without requiring owner's consent. These rights go well beyond mere consultancy and indicate that appellant was active participant in core operational activities of the hotel. Appellant's contention that absence of exclusive or designated physical space within hotel precludes existence of a permanent establishment is misconceived. In Formula One case, the court expressly held that exclusive possession is not essential. Temporary or shared use of the space is sufficient provided business is carried on through that space. Actual role of appellant is not just advisory in nature but extends to other administrative roles. In this case, 20-year duration of the SOSA coupled with appellant's continuous and functional presence satisfies test of stability, productivity, and dependence. From nature of functions carried out by appellant, it cannot be said that they were performing merely auxiliary functions. Rather, functions performed by the appellant through its staff operating from hotel premises were not just limited for setting up pattern of activities for hotel, but were core and essential functions, clearly establishing control over day-to-day operations of hotel. Moreover, they were to be continuously performed over a period of 20 years under agreement that included revenue sharing. Therefore, hotel premises clearly satisfy criteria required to be classified as a fixed place of business or permanent establishment. Appellant's further submission that daily operations were handled by HYATT India Private Limited, a separate legal entity, does not decisively support its case. It is well established that legal form does not override economic substance in determining permanent establishment status. The extent of control, strategic decision making, and influence exercised by appellant clearly establishes that business was carried out on through the hotel premises satisfying conditions under Article 5(1). Additionally, reliance placed by the appellant on electronic funds is wholly misplaced. Decision is distinguishable on the facts. In that case, Indian subsidiary merely provided back office support and was compensated on arm's length basis with no involvement in core business functions. In contrast, in present case, hotel itself was the situs of the appellant's primary business operations carried out under its direct supervision and aligned with its commercial interests. It is undisputed that appellant's executives and employees made frequent and regular visits to India to oversee operations and implement SOSA. Findings of the assessing officer based on travel logs and job functions established continuous and coordinated engagement even though no single individual exceeded 9 months stay threshold. Under Article 521 of the Direct Tax Avoidance Agreement, relevant consideration is continuity of business presence in aggregate, not length of stay of each individual employee. Once it is found that there is continuity in business operations, intermittent presence or return of particular employee becomes immaterial and insignificant in determining existence of a permanent establishment. High Court was correct, said Supreme Court, in concluding that appellant's role was not confined to high level decision making, but extended to substantive operational control and implementation. Appellant's ability to enforce compliance, oversee operations, and derive profit linked fees from hotels' earnings demonstrates clear and continuous commercial nexus and control with the hotel's core functions. This nexus satisfies conditions necessary for constitution of a fixed place permanent establishment under Article 5(1) of the India-UAE Direct Tax Avoidance Agreement.